defendants Don Lemon and others, and their motions are hereby denied. And additionally, accordingly, Don Lemon loses again. 3 for 3. What a total failure, Don Lemon. You lose Brady, you lose grand jury, and you lose your discovery deadlines.
Grace and peace, everybody. You saw the thumbnail, you saw the title. You know what we're going to do. We've kind of forgotten about Don Lemon and the whole assault on the city's church up there in Minnesota. Well, there is an update. We're going to bring Robert in, Esquire, up in here, watching the Watchers. We're going to check them out and get an update. This is a very interesting story, and it's not over. So let's bring him in. Let's go.
Loses a big one. Remember, he got charged with a crime for being one of the co-conspirators who invaded the Christian church and started screaming and shouting at people as part of a big entourage of individuals. Well, now the District of Minnesota just handed down a new order, which he's not going to be happy with. And the decision came down from Douglas Miko, the same judge whose wife works for Keith Ellison in the AG's office. And he explains exactly what happened here. The main defendant is Nekima Levy Armstrong. She was one of the people organizing the mob. Don Lemon was there, and they were feeding off of each other. Don had his live stream gear. He was spreading the message, one half of the operation. She had the crew. She needed an audience to perform in front of. Don Lemon gave it to her. Don Lemon needed some content and to be an activist and to go and interfere with a Christian mass in process. So they were helping each other in this conspiracy. Judge says, all right, this matter that is before the court involves Don Lemon, Georgia, Shane, Michael Butte, and they all want access to the grand jury proceedings. And let's not forget, this judge did not want to indict them. Criminal complaints were filed against Don Lemon, and he said, no, he's got a First Amendment right or whatever. So they bypassed the judge. They went to a grand jury and they indicted them. The grand jury said, yeah, that's definitely a crime. That judge is an idiot. Then the case got reassigned back into the same judge who originally didn't think that there should be a criminal complaint that was submitted. He said also before the court, so they want grand jury proceedings to challenge the indictment. Also before the court is Don Lemon's motion for an immediate disclosure of Brady materials and another extension of discovery deadlines. The government, the DOJ prosecutors, they oppose each of these motions. They say, no grand jury materials, Brady materials, you'll get those. We're not giving you stuff early. We're not letting you pierce the secrecy shield of grand jury proceedings. And a bunch of motions have been submitted back and forth, all listed here. Now, for the reasons stated below, defendants Don Lemon and others and their motions are hereby denied. And additionally, Lemon's other motions
so
are
dramatic,
also denied as being moot. So you lose, Don. On February 26th, remember, the government charged 39 lunatics.
That was crazy.
By indictment with one count of conspiracy against right of religious freedom at a place of worship in violation of U.S. law. And remember, Biden went after people. If you showed up at an abortion clinic and you so much as looked at somebody cross-eyed, then they would charge you and arrest you for interference with their religious rights, which is to eliminate babies. They also had one count of injuring, intimidating, and interfering with exercise at a religious place of worship in violation of other law. The superseding indictment, which is version 2, alleges that on January 18th, 2026, these defendants entered the city's church in St. Paul, Minnesota, after religious services had begun and engaged in acts of oppression, intimidation, threats, and interference in physical obstruction. And as a result, the congregation was forced to terminate the church's worship. Lemon and others, they say in their motion, well, there were very likely factual and legal misstatements in the indictment. So all of the charges should be dismissed because the material that was presented in the grand jury proceedings was a misstatement. They say the government grossly misrepresented facts and law to the grand jury in order to get them to actually indict them. Similarly, the other defendants argue in their motion that there was also reason to believe, based on other flaws in the indictment's allegations that the government provided a misleading legal instruction and failed to ensure that the grand jury engaged in an individualized defendant by defendant assessment of probable cause, saying that the prosecutors went in front of the grand jury, made improper commentary or improperly rushed their deliberation or claimed that there was a national emergency going on, and the whole thing should be thrown out. According to Don, they have demonstrated a particularized need to overcome the presumed secrecy of grand jury proceedings and get the information and the materials inside so they can make their defenses and beat the charges. Now, the government, they say that Don Lemond's arguments of impropriety before the grand jury are all speculation, and therefore he has shown no particularized need at all, justifying the disclosure of any of the grand jury materials here. But in any event, says the government, we're not even required to present any legal instruction or any exculpatory evidence to the grand jury, so all those motions should be denied anyways. Now, as for defendant Don Lemond and their demand for an immediate disclosure of this Brady material, they also said the government's indictment of an innocent person underscores the need for the remaining defendants to get Brady materials and discovery without further delay. The government says that it will produce any Brady material related to Miss Lewis's dismissal in accordance with the court's scheduling order, and that an order for immediate disclosure of any such material is unnecessary. So you'll get your Brady material, which is exculpatory information,
when we give it out,
when we have to give it to you, but not earlier. So the judge writes, Don Lemond and the defendants, they aver that they will seek dismissal of this superseding indictment because they say there were, from their vantage point, the extraordinary course the government took to go get the superseding indictment and the alleged public misstatements of law by DOJ officials about this prosecution must have infected the grand jury proceedings, such that the government lawyers, the prosecutors, provided similarly faulty legal instructions and withheld other exculpatory facts from the grand jury in order to secure the finding of probable cause to charge them. Now, all this, according to Don, amounts to a particularized need justifying the disclosure of the grand jury materials, which, as we know here, are secret. The government, though, denies that. They say any DOJ official never actually misstated the law at all. And even if they did publicly misstate the law, says the government that the defendants have failed to show that the counsel of record made similar statements to the grand jury. According to the government, the defendants, Don Lemond, they have failed to connect any of the legal misstatements out in public or factual misrepresentations to any of the proceedings in this case. So they can't carry their heavy burden of showing a need for the disclosure. Judge says, but whether the grand jury was provided faulty or firm legal instructions or presented with facts exculpating defendants is of no moment, because a prosecutor is under no obligation to actually give the grand jury legal instructions, nor do prosecutors have a legal obligation to present exculpatory evidence to the grand jury. Judge explains, let's look at the rules of criminal procedure, saying the court may authorize the disclosure of grand jury matters to a defendant who actually shows they need it. If you want it, you have to make a strong showing of a particularized need for the materials. You can do that if you show the sought after material is needed to avoid a possible injustice in another proceeding, or the need for the disclosure is greater than the need for secrecy, or the request covers only the needed material. So three things. Conjunctive. The material is necessary to avoid injustice in another proceeding. There's a balancing test. Disclosure outweighs secrecy, and it's narrow and limited. But a generalized hope to get your hands on it or arguing some defect in the proceedings is not enough, because every defendant everywhere will make that argument. Rather, a particularized need requires presenting specific evidence of prosecutorial overreach. And a defendant who has not pointed to anything in the record which actually might suggest that the prosecution has engaged in improper conduct fails to carry his burden. And under the laws of this circuit, a prosecutor is not under an obligation to provide the grand jury with any legal instructions at all. Another Eighth Circuit case from 1988. Somebody dismissed an indictment, but they shouldn't have done that because the prosecutor did not instruct them on the law of obscenity. And the prosecutor also, according to another Eighth Circuit case, is not under a duty to disclose facts to the jury, which would be the basis of a defense at trial. Once you're charged, then you can make your defense known, and at a trial, present all of that evidence to the jury. The DOJ doesn't need to do that for you. They then point to misstatements by high-level DOJ officials. They say Trump made a comment about this, and they said the government provided improper legal instruction. They also argue the government failed to provide exculpatory evidence, and therefore, since they didn't do that, they misrepresented the facts. They assert that because of these flaws, this warrants dismissal of the entire indictment. They all walk. They say because of those arguments, we need it, and that's particular. So give us the materials. But the judge says, no, there are at least 3 problems with Don Lemon's position, and many more problems with Don Lemon in general. First, although Don points to specific statements by DOJ officials and the president that they claim may have influenced the proceedings, this does not translate to a showing that those involved in actually presenting the matter to the grand jury in that room, that they made any inappropriate statements or that they engaged in improper conduct. So what if the president said something, he wasn't in the room? And that is the more salient inquiry when it comes to grand jury proceedings. Quoting, defendant who has not pointed to anything in the record which might suggest that the prosecution did something improper has failed to carry his burden. Now, this is not, after all, a motion to dismiss based on outrageous government conduct at all. And second, even accepting the defense theory that the government provided erroneous legal instructions, the government is not under an obligation to provide any legal instructions at all. Quoting, thus, even if we further assumed that the grand jury was not properly instructed, we would not dismiss the related counts, and we would have no permissible basis to invade the secrecy of the proceedings. And so therefore, a challenge to an instruction to the grand jury is not a proper basis for the dismissal of an indictment that is valid on its face. And here, although Don Lemon and the others allude to motions to dismiss that they intend to file, there is nothing before the court challenging the facial validity of the indictment. So essentially, they're fishing for the materials. And finally, as for Don Lemon's theory that the government may have failed to provide exculpatory evidence to go in there and say, well, Don could be innocent because of this, the government and governing law requires no such disclosure. The grand jury sits not to determine guilt or innocence, that's a trial, but only to assess whether there is an adequate basis for bringing the charges in the first place. And likewise, an indictment need not anticipate the defendant's defenses. So even accepting for the purposes of this motion that, yeah, let's say, okay, fine, they did fail to provide proper legal instruction, no one cares, and exculpatory evidence, neither of those serve as a basis to dismiss the indictment, period. They rely on the Comey case to say that the court should order the disclosure of the materials, but Comey's different. In that case, the particularized findings of the court did establish that grounds may exist to dismiss the indictment because of a matter that occurred before the grand jury. And we talked about that on yesterday's show when Comey, the search warrant that led to evidence that was presented to the grand jury may have been problematic. And that's what the judge found. Here, even accepting that the government provided improper legal instruction and failed to present exculpatory evidence, that does not establish a ground to dismiss an indictment. And so therefore, Don Lemon and his people have presented no permissible basis at all to invade the secrecy of these grand jury proceedings at this time. And so accordingly, Don Lemon's motion is denied. So next they asked the court for an order saying, we want disclosure right now. Immediately give us all Brady material, including grand jury materials, and we want an extension of discovery deadlines. They say the government charging an innocent person, so somebody else got charged, and I think they dismissed the charges against her. They say, well, and they may have just gotten somebody wrong, or they may have talked to her and she said, actually, I was kind of, forced in there. I wasn't a part of them. They said, okay, good to know. So now we dismiss your case. They say, well, you dismissed hers. So that means you screwed up over there. Yeah. But as even the defendants note in their motion, the court has ordered the government to immediately disclose any materials under Brady already. And the court has issued the same order for every defendant in this case. And he cites them all right here, all of them listed. So because the court has already ordered the government to timely comply with its Brady obligations and warn the government, if you don't do this timely, there will be consequences. We may exclude evidence against you. We may give the jury an adverse instruction. We may dismiss charges. We may hold you in contempt. You may be hit with disciplinary actions and other sanctions. The court's not going to do that again. And so your motion for an order directing the immediate release is denied as moot. I've already ordered that. Now, as for your request for permission to file a motion to reconsider the discovery deadline, also denied. Failures. When you filed your motion, the deadline was April 24th. That deadline is passed now. Then litigation over the government's discovery was postponed until May. That deadline is also passed too. Because the government discovery deadline has passed, now your request to file a motion for reconsideration of deadlines is moot. And so accordingly, Don Lemon loses again. 3 for 3. What a total failure, Don Lemon. You lose Brady, you lose grand jury, and you lose your discovery deadlines because you're a moot and you're moot. Denied. Signed by Judge Douglas L. Miko.
El
in a
Miko.
3-for-3
Le Miko.
blowout. So Don Lemon loses again. And that was the judge who actually didn't want to charge him in the first instance. So very nice to see it. And we'll keep our eye on this one to see what is coming next for Don Lemon, but he's not going to get ahead of the game. He's not allowed to jump and cut in front of the line to get access to info to which he's not entitled. And he's not allowed to pierce the grand jury secrecy. He's not James Comey. He's Don Lemon. So his lawyer's blown out. I think Abby Lowell was one of his attorneys, blown out. But they'll continue to try. They'll continue to grasp. And we'll keep our eye on this case until Don Lemon goes to jail.
All right. I mean, I want him to go to jail. I just don't know if they're going to do it. What do you think? You think Don Lemon? I agree with Robert that he should go to jail. I just don't know if they're going to put him in jail for what he did. Because, he attacked the Christian church and they're not going to. Now, if he had attacked a Muslim mosque or a Jewish temple, maybe we'd have a discussion. It was a Christian church. What do you think? Let me know. Comment down below. Give me your 2 cents. I appreciate it. And I'll keep giving these updates. So definitely let me know in the comments if you like these updates. I have not been keeping up with the Don Lemon case, but as things go along, if I run across it, I'll make sure I do a quick video and explain it. So thank you so much. I appreciate y'all so much. Until next time, grace and peace. Thank you so much for tuning in to another episode of the JWhit Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.